President scored a big win as the Supreme Court announced it would uphold his health care law, but not in the way that most of his supporters believe the justices would. So how does the penalty linked to the individual mandate amount to a tax when the government has often argued it is not a tax? Let's ask a couple experts here. Elizabeth Wydra with the Constitutional Accountability Center and Beth Melito from the National Federation of Independent Business. And by the way, NFIB was a plaintiff in this landmark case. Welcome to you both.
Thanks so much, Shannon.
Thank you, Shannon.
All right, Elizabeth, you all supported this law and filed briefs and were involved in the case as well. Most folks thought this would come down to the Commerce Clause. Were you surprised at all, though happy to win under the taxing power?
You know, I wasn't terribly surprised that it was upheld under the taxing power. I think that there are so many bases for upholding the Affordable Care Act in the Constitution's text and history that the court chose the tax power, and I think that that was a great victory for the Obama administration, for the Constitution, and frankly for the American people. But it is a big loss, I think, for the Tea Party in particular, who just had their centerpiece argument that Obamacare was unconstitutional rejected not just by the highest court in the land, but by conservative Chief Justice John Roberts, who essentially told them, you need to go back and read your pocket constitutions a little more carefully.
And we're going to talk about the politics of this more later, because the Tea Party now rallying and saying they're feeling energized for the fall. We'll get into that a little bit later, but back to just the case itself. Beth, your business owners had sued because they were worried for a number of reasons about how this was going to impact them. The fact that this has now been labeled as a tax and it has been upheld as constitutional, what's the reaction?
Well, if it was unpopular before, I mean, it's going to be even more unpopular now being called a tax, that's for sure. I mean, Thursday was a sad and disappointing day for small business owners. It was a big loss for small business. And the fact that I think no lower court had upheld this law under this tax and spend clause, I think that is worthy of note too. And the fact that you had the president himself come out on television and say this individual mandate, the provision that everybody go out and buy health insurance or pay this penalty, is not a tax. It's a penalty, I assure you that. I mean, I think that's very telling too. So it was a very sad and disappointing day for NFIB and for the small business owners, and I think for our country too.
All right, Elizabeth, obviously you all are on complete polar opposites of what this, how it impacts and the law itself. But let me ask you about some language that was woven through by the Chief Justice in the majority opinion, where he talked about we're not going to get into the merits, essentially, or into the wisdom of this law. That is left to the people to make that call, essentially sounding like he's saying if you don't like the folks who passed this, then maybe you go back to the ballot box and change that. Would you have preferred stronger language in support of the law, or were you happy to get what you got? I mean, you know, you didn't get the Commerce Clause. Do you worry that the limits that the Chief Justice put on the Commerce Clause will impact similar pieces of legislation down the line?
No, I don't. I think that, especially if you take the challengers at their word that the so-called individual mandate was so unprecedented and nothing has ever been like this, then frankly, the Commerce Clause language in the opinion shouldn't really affect any of the other social welfare legislation that has been passed since the New Deal, including Social Security and many other wonderful programs. And with the language about, you know, we're not here to pass on the wisdom of the law, I thought that was entirely appropriate. It's very important to remember that the Supreme Court is there to adjudicate the law, to say what the Constitution means. And they're not there to be, you know, essentially second-guessing Congress about what laws are best and what laws should be passed. They're there to say whether it's constitutional or not. And Chief Justice Roberts was entirely right that whether you think the law is good or bad, it's constitutional.
All right, Beth, what does this mean now for your business owners moving forward? How will they work with the result they've got?
Well, I mean, certainly, as I said, we're disappointed in the result, but we will respect the decision of the majority of justices there. But it is very frightening. I mean, and I would argue, disagree with Elizabeth, that in fact, the majority of the court did rewrite the law. They did not interpret it, and that's what, you know, the dissent, you know, said too, is that, you know, this was a penalty, not a tax. It was contained in, you know, Section 1 of the law, which talked about the individual mandate. All the other tax components were in a different section of the law. So we wonder too, our members wonder too, what does this mean going forward? Is Congress going to do a bait and switch again? Because that's essentially what happened here. It was a penalty, now it's a tax.
Well, it's a fascinating opinion. I read it again last night, and I'll probably read it many more times. And every time you do, there are new contours to it. So we thank you both for coming in to share your viewpoints.
It's a pleasure.
Thank you very much.